Welcome, everyone. I think we're going to go ahead and get started today. I know we have a few people that are still logging on, but I think we'll go ahead and move forward. Thank you so much for joining today. We're going to be covering wage and hour laws in the healthcare industry. I wanted to give you a brief introduction to Holland & Hart and to me. I am an attorney partner at Holland & Hart. I've been here for 13 years. My name is Nicole Snyder, and I am both a business attorney and obviously an employment attorney. I also serve as the administrative partner of the Boise office of Holland & Hart, where I help manage about 80 people. So in addition to my legal practice, I also work from time to time in managing our own law firm workforce. I want to also say thank you quickly to all the Holland & Hart clients who have joined the webinar. We appreciate you very much, and we're glad that you're joining us today. And of course, to anyone else who's not a client, we'd love to have you as a client. So thank you, everyone, for joining us this afternoon. A few quick housekeeping items. You should be seeing PowerPoint materials on your screen right now, and they should have been mailed to you yesterday with a link. All the participants on the line are muted, so we can't hear what you're saying, but there is a chat function on the webinar where you can submit questions, and I encourage you to submit questions during the presentation. I may take those up at the end, but if we run out of time, then I will try to follow up with you at a later date to see if I can answer any questions that arise during the presentation. Our topics today I'm going to go through. If we can get to the next slide, sorry about that. Here are the topics that we're going to be covering. I just want to put a warning and sort of a caution out to everyone. We have 100 people registered for the webinar today, and I looked at the registration list and realized that we're crossing many, many states. So this presentation is necessarily not tailored for state law. In many cases, it will cover state law, but sometimes it will not. State laws vary, especially in the employment arena, so it's very important to understand that we're covering federal law and that there could be variations that are important to know under your state's jurisdiction. The other warning I want to throw out, of course, is that this presentation really can't be construed as legal advice because every situation is simply very different. So please understand that we may cover things in a very general manner, and there may be more detail that's very important to any arrangement that you have. So just a grain of salt as we walk through these. But that said, I really hope that these topics are helpful to all of you, and in some cases a good overview, but in all other cases an update on where we are with wage and hour in the healthcare industry. So here are the 5 topics that we're going to be covering. The first one is the recent trends in enforcing wage and hour laws. 2 is understanding risks of failing to pay overtime and minimum wage. 3rd is determining whether employees are properly classified as exempt from minimum wage and overtime. And then 4th is appropriate arrangements for independent contractors. And then finally, we'll talk a little bit about internships, which seems timely given that we're rolling right into summer and a number of your organizations may be considering whether and how to engage in interns. So with that, we're going to jump right into the first topic. And the Fair Labor Standards Act is the law that governs overtime and minimum wage arrangements. It was first approved in 1938. It's nothing new. It was codified as 29 U.S.C. Section 201. The Fair Labor Standards Act impacts a lot of employees. It's 130 million workers in the United States, and it's enforced by the U.S. Department of Labor Wage and Hour Division. And what that means is we have both federal enforcers and we also have state enforcers that will enforce these laws, as many of you know, in dealing with state Department of Labor's or equivalents in your own state. So let's jump right into overtime. And the rule, of course, is that all non-exempt employees must be paid overtime pay at 1.5 times the regular rate of pay for either all hours worked over 40 hours in a week, or, and this is unique to the healthcare industry, all hours worked over 8 hours in a day and over 80 hours in a 14-day period. Now, just a note in case you've come from another industry, or if you're moving into one or you're not in the healthcare industry, is that 8 hours and 80 in a 14-day period is applicable only to hospitals and to certain healthcare establishments. So most businesses simply have to pay time and a half for any time over 40 hours a week. And all hours worked over 8 hours in a day and over 80 in a 14-day period is something that a healthcare establishment must elect in order to choose as the way that it chooses to pay overtime. So there's a big difference there. And the other thing with the 8 hours in a day and over 80 in a 14-day period is it's both. It's not simply whether the employee works over 80 hours in a 14-day period. They also get overtime anytime they work over 8 hours in one day. Just a note at the bottom there, approximately 85% of all employees in the United States are non-exempt, meaning they are entitled to overtime. So the vast majority of most organizations are tracking minimum wage and overtime requirements. So let's talk about which employers are covered under the FLSA and which employers have to pay minimum wage and overtime. Here's the criteria, and I've put in red the ones that are most likely applicable in the healthcare industry. So the first one is private sector employees with $500,000 or more in revenue, or 2 or more employees engaged in interstate commerce. And what we mean by interstate commerce is doing business across state lines. The second, very applicable obviously to today's presentation, is hospitals and other healthcare institutions. The next one, also very applicable to healthcare industries, is public sector employees. The last one, agencies, subdivisions, authorities, and districts of state and local governments. The next one, elementary and secondary schools and institutions of higher education. Second to last, most nonprofits, which also can cover some healthcare institutions. And finally, trade associations. So as you can see from this list, almost everyone is covered. It's very rare that you can find an organization that is skirting between any of these requirements. I have a question. A few people have noted that they're muted, and that's correct. Everyone is muted, so if you have questions or comments, go ahead and submit them in the chat screen, and I will either answer them at the end of the presentation or I will follow up afterwards. Thanks. So talking about risk on overtime and minimum wage, a question that inevitably arises when there's a problem from our clients is this anything that I personally need to worry about? And unfortunately, the answer is yes. Any person, and here's what the law says, any person acting directly or indirectly in the interest of the employer in relation to the employee who has these elements or these powers, the power to hire and fire, the power to control the schedule of work or conditions of employment, maintenance of records, and control over the method or rate of payment, and control over the business enterprise could, in some cases, have personal liability. So this is a really important point because I think a lot of us think of this type of liability as only hitting the organization, but in fact, at times, employees of organizations can also have personal liability. So this is a fairly important point. This may be something to take back to your managers or to your business people and make sure that you have any insurance coverage available to you in your position if you are the person who has these powers that I've just gone over. And then also there's possible criminal penalties too. Those are unlikely but can be done in knowing and intentional cases. Going through recent trends, one of the trends that we've noted with the Obama administration is that there has been a concerted effort to target overtime and minimum wage violations. This was part of a plan adopted in 2010 called Plan, Prevent, and Protect. Employers and others in the department's regulated communities must understand that the burden is on them to obey the law and not on the Labor Department to catch them violating the law. Compliance will be non-negotiable. And so what we've seen over the past several years is we've seen a very large increase in collective actions and in actions that are initiated by the Department of Labor. In years where the administration is not so concerned about enforcing these, then they're often initiated by employees who are complaining. But this is a case where we've actually seen a lot of initiation by the government, and then the government willing to sort of shepherd through class actions with multiple employees. So what does that mean? Well, I want to go through the calculation, and again, this is, I think, helpful in some cases for you to understand and be able to advise your business people what it means and why this is really important. It's not merely that you may have one person who all of a sudden you have to start paying overtime and minimum wage to. This is how it works. So the calculation in the formula is below. The cost of misclassification is equal to the number of hours that are over 40 times 1.5 of the regular rate. It'll go back 2 years under the statute of limitations if there is not a willful violation, or 3 years if it's willful. Then you take that number and you times it by 2, which results in liquidated damages, and then you times that by the number of employees, and then you have to add in the attorney fees for both yourself, your organization, and for the employees who are suing, and then if it leads to litigation, of course, and then the cost of the employees participating in the litigation and being distracted from their normal productivity. So as you can see, if you take this and going back 3 years with, even a small group of employees, it quickly can add up to a very, very big number and can literally get to millions of dollars pretty darn fast. So that's why this can be such a big liability for organizations. So let's talk about how to properly classify someone. And really what I'm talking about is any kind of a self-audit, whether it's looking at any employee and saying, okay, do we need to pay this person overtime minimum wage, or if you're saying, gosh, I'm not real comfortable with where we are with this class of employees or with all employees, so let's go through each of them and do a self-audit and make sure that we're okay. So here's the starting point. For any employee who's making $23,660 per year, which is $455 a week or less, then aside from an outside sales position, they're automatically eligible for overtime. The next one, if they're making $23,660 per year or more, then you have to look at the duties. You have to look at each of the employees and ask, not necessarily what their title is, although that's a starting point, but what exactly are their duties, and do they qualify for an exemption from overtime and minimum wage? And really, I guess what I'm talking about here is overtime, because minimum wage would be covered by that amount. So when you look at an employee and you're trying to figure out how they should be classified as exempt or non-exempt, what you're really looking at here is what their primary duty is. So the definition does not strictly require 50% of the time. What we mean by primary is really, what is this employee's principal, main, major, or most important duty? What is the primary duty? What is it that they do most of the time, or what is their most important function? So the primary duty of an exempt employee's work may consist of the duties that meet 2 or more exemptions. And now I'm going to go through those exemptions so that you understand what the possibilities are for saying someone is exempt from overtime. And the first one that I want to cover is the executive exemption. And this is in some ways one of the easier exemptions to apply. With the executive exemption, the primary duty is management of a recognized separate department or a subdivision. What it means is that that person is customarily and regularly supervising 2 or more full-time employees or equivalents. They have the authority to hire or to fire employees, and to recommend hiring, firing, and advancement, deal with promotions, and that they're given a lot of authority, or they're given a lot of credence into what their opinion is as to how this person is managed. In a standalone business owner, so anyone who owns 20% or more equity in the business and is actively engaged in management is also automatically exempt from overtime requirements. So that's the executive exemption. The administrative exemption, unlike the executive exemption, is a bit tricky. And honestly, this is the one that gets litigated most often, because people hear the word administrative and they think Everyone's administrative who's working in management or back office or secretaries, and that really is not what is meant by the administrative exemption. So here are the requirements. The primary duty of the administrative exemption is office or non-manual work, but it has to be directly related to management or general business operations of the employer or employer's customers and clients. But here's the second one. The primary duty includes exercises of discretion and independent judgment with respect to matters of significance. So this is why almost any secretary or administrative assistant will never qualify for the administrative exemption, because while they do important things and while they're carrying out important tasks, they don't have a ton of discretion or independent judgment with respect to matters of big significance. We need to have them making significant business decisions on behalf of the organization. We need to have them managing key pieces and key employees in order to qualify for this. So, and the third bullet says generally they're doing claims adjusting, financial services, HR, auditing, tax, marketing, and quality control. These are typically the categories that they fall into. But again, just because someone's in HR or just because someone's working in marketing, you know, there are a lot of times when those employees aren't going to qualify as exempt under the administrative exemption. You have to go back to the second bullet and ask, how significant are the decisions that this person gets to make, and how big of a deal are they for the organization? Here's a slide that talks a bit more about that piece about the discretion and independent judgment. And here's a checklist that you can use to start asking those questions. So does the employee evaluate options and select a particular one? Do they create or implement policies or operations for the organization? Do they conduct significant projects? Do they have a signing authority? Can they sign a contract on behalf of your organization and bind you to a purchase or to an obligation in the future? Do they have the authority to vary from settled procedures? Do they provide expert advice to management? Do they handle problems as they arise, or do they recommend how problems should be handled? If all of these are a yes, then it could be the case that you're starting to get someone who's going to be qualified. I think that if the answer is no on any of these, then it's probably a pretty serious indication that they're not going to be exempt from overtime. But this is the checklist to start to go through to make sure that the person is falling within this exemption. The next exemption is called the Learned Professional Exemption, and this is one that comes into play a lot of times in the healthcare industry. So the primary duty in this exemption is the performance of work that requires an advanced type of knowledge, and you can see why this comes into play because it's very typical of jobs where medicine is a key part of the business and the duties. It's predominantly intellectual in character. There's a consistent exercise of discretion and judgment in science or in learning, and obviously science is the one that we see a lot in the healthcare industry. There's a prolonged course in specialized intellectual instruction, at least a bachelor's degree, but many times beyond that. It covers a lot of times accounting, which I know that some of you employ accountants. It covers law. Some of you have in-house counsel. Education, which can be a component of some nonprofits or other public institutions. Medicine, of course. Engineering, theology, and architecture. Some examples include degreed physician assistants, chefs, RNs, CPAs, funeral directors, and athletic trainers. Once in a while, but not usually, a non-degree holder will qualify. It's not that typical, but it does happen. I'm going to pause. I have a question from someone on the chat screen whether the slides will be available later. Yes, they actually should have been emailed to all of you yesterday, but I will follow up and make sure that we email them out in a separate email after the presentation as well. So here's some specific examples in the healthcare industry in this exemption. We have RNs, generally yes. LPNs, generally no. Nurse practitioners, generally yes. Physician assistants, generally yes. Again, the degree there is key. Respiratory therapist, it depends. And pharmacist, generally yes. But here's a good place for a timeout to say, as a reminder, that titles really don't matter. What really matters in all these, and this isn't just for this particular exemption, but it's what the duties of the person are. And so again, it's a matter of going through the requirements and asking, aside from what this person's title is, do we have an RN who, although she's an RN, she's actually fulfilling quite a different function within the organization. So that doesn't necessarily give us a free pass. That just means that we still need to go through the analysis and make sure that they are getting, that they are falling within one of the exemptions. Next exemption is called the Creative Professional Exemption. And I know that this may not sound healthcare oriented, but the fact is some organizations are large enough that we do, in fact, employ creative professionals within a healthcare organization. So here the primary duty is the performance of work requiring invention, imagination, originality, or talent in a recognized field or artistic or creative endeavor. So what we're looking here for is someone who is doing a lot of music, writing, acting, or graphic arts. Really the key with the creative professional exemption is how much of their own creativity they're applying as opposed to carrying out specific marketing plans or working on things that are sort of preordained by someone else. This is really meant to reach artists or performers. And then next, a bit more applicable to everyone, is the computer professional exemption. This has kind of been a hot button item for a number of organizations because for some organizations they hear they will have an IT person and they will assume automatically that the IT person, because they have specialized knowledge about IT systems, that they must be exempt. And that actually is oftentimes not the case. Their primary duty has to be the application of systems analysis techniques and procedures. They have to be consulting with users to determine hardware, software, or system functional specifications. The other thing is that last bullet is usually what trips people up, which is the creation or modification of computer programs related to machine operating systems. What we're really looking for to make someone exempt in the IT field is someone who is overseeing an entire system within your organization. It shouldn't be someone who's functioning merely as a help desk person where people call and say, I'm having problems with my computer. It has to be someone who's overseeing the entire system, who's often doing a lot of buying of software and hardware and installing and consulting and troubleshooting for the entire system. So this might be like, for example, a director of IT or someone who wears that hat in connection with their other management duties, but it's not, again, going to typically be someone who you see is running a help desk. And then we have the outside sales exemption, and I won't spend a lot of time on this because outside sales aren't always typical or aren't very typical of a healthcare organization. But that said, pharmaceutical sales reps there at the bottom, they are generally exempt. In addition, you could, of course, have people who are associated through another part of your business who are doing some kind of outside sales. What it does not cover, and where people sometimes make a mistake, is someone who is doing inside sales, meaning they come to the organization, they're doing sales by mail, telephone, and internet. And what they really have to be doing is they have to be engaging in work away from the place of business, which doesn't mean the person's house. It just means that they're going and meeting with people and making their sales on the road. Next exemption is highly compensated employees. So for anyone who's making $100,000 or more, they're exempt if they meet any one of the criteria of the executive, administrative, or professional duties. So that's important. Note that if someone makes $100,000 or more, it does not mean that they're automatically exempt. They still have to meet one of the criteria from those other exemptions. They have to be doing office or non-manual work. They have to be significantly higher than $65,000 in proposed regulations, and they have to have $100,000 coming from salary, commissions, and non-discretionary bonuses. So generally, If an employee is exempt, then they have to be paid their full salary for all weeks in which they perform any work, regardless of the quantity or quality. So now I want to cover the situation where you've determined someone is properly exempt, which is great. That means we don't have to normally pay overtime. And now the question is, okay, I have the salaried employee. What can I do? Can I deduct anything from their wages, or when they don't show up for a couple hours? Or what if they're performing poorly? Or what do I need to do when they want to take a half day off? And here's the rule. If they perform any work, regardless of quantity or quality, they have to be paid their full salary for that week. Here are the limited exceptions to that, which is you can deduct for an absence from work for 1 or more full days for personal reasons other than sickness or disability. So if that is your policy, and again, it's important to have a policy that states this, and you allow someone to take a personal leave day, you can deduct that from a salaried employee without inadvertently converting them to an employee who's eligible for overtime. Absences due to sickness and disability for a full day, if the deductions are made under a bona fide plan, policy, or practice of providing replacement pay for these types of absences, will allow a deduction. And you can do no deductions, only offsets for jury fees, witness fees, or military pay. Deductions of any type may be imposed in good faith for violating safety rules of major significance. I think this one is a little risky, but in some industries it's very critical to the way that employees are managed. So some institutions will have a policy where if there is a safety rule that's a really big deal, then they have a policy that allows deductions even from a salaried employee for violating those safety rules. Number 5, unpaid disciplinary suspension of 1 or more full days imposed in good faith for violations of workplace conduct rules. So for example, if you have a clear sexual harassment or a workplace policy, and then you also have a policy that says that if you violate these, we can suspend you without pay for some period of time, then that is also a possibility. I want to point out that on numbers 4 and 5, the risk in doing those deductions are state wage and hour laws where someone claims that there was a wrongful deduction. And I'm always a little hesitant to advise clients to make a 1 or a 2, whatever it's going to be, a couple $100 days deduction, because the way, for example, in Idaho that a wage claim works is if you make a wage claim, you can claim up to 3 times the amount due and owing for that deduction. In addition, of course, now we have the risk that a salaried employee has been converted to an employee who's entitled to overtime. So you have to be really certain and very comfortable with the employee's performance or their workplace conduct violation, because if a decision maker at the Department of Labor or a court decides that it was not properly made, then you're looking at quite a large world of potential damages if the employee brings a claim. So I always put a big caution in front of numbers 4 and 5 about whether it's worth it or whether there are simply other ways to deal with documenting performance problems and dealing with problem employees. Number 6, the proportional rate of a full salary for time actually worked in the first and last weeks of employment. So for example, if you have someone starting a job or ending a job on a Wednesday, you don't have to pay for that full week, even though they're a salaried employee. And then another deduction that you can make, assuming your policy says so, is that you can deduct for any unpaid leave taken pursuant to FMLA, which of course can from time to time cover intermittent leave that is just a few days a week, a few days or even a few hours. I want to talk briefly about makeup time versus comp time. For private employers, all wages must be paid for the pay period at issue, and makeup time cannot be extended outside of the work week. So what typically happens is you can't, and this is a common violation, a lot of times people don't realize it, is if you have an employee who wants to take some time off, but they say, don't worry, instead of working 40 hours this week, I'll work 38, and then next week I'll work 42. The problem with that is that you still don't have to The problem with that is that you still have to pay overtime for the week in which they worked the 42 hours, even though they only worked 38 in the prior week. For public employees, including public hospital employees, compensatory time can be accrued up to specific limits and must be reasonably available for use and must be paid out of termination. So comp time is something that is actually unique to the public hospital and public employee work pool. So you may have a compensatory time policy. It needs to be clearly stated, and it needs to follow the rules for use. So I'm going to give a quick example of make-up time versus comp time problems. So Scott and Dean are non-exempt employees for a private hospital. They want to take off early on Friday because Dean is struggling with finding a birthday gift for his wife, and Scott offered to help with the shopping. To make it up, they proposed to work 10 hours the following Monday. You're fine with the plan, but don't want to pay them overtime. Do you have to? And the answer is yes, you do, because they're non-exempt employees and there's a 40-hour work week. The only exceptions would be you would have a slightly different situation if you were on the 8-hour a day and 80 hours and 14 days. But note that any day that they work 2 hours, if they work longer than 8 hours, you have to pay overtime. So in effect, when you do the math, it comes out the same. On that day that they're working 10 hours on Monday, you still have to pay overtime. So now let's talk about work time and what we really cover when we mean work time, because this is a big deal in the healthcare industry. We have a lot of employees who are asked to be on call, and in some cases we have to pay for it, in some cases we don't. So what do we mean by work time that someone's actually going to get paid for? Work ordered by the employer or that the employer allows the employee to, quote, suffer is the word that they use. I guess for many of us who are suffering through our jobs, suffer makes sense. It's kind of a funny use of a term, but nonetheless. Work that we tell someone they have to do, and that includes telling them to wait sometimes to work, or that we allow them to do, is work that has to be paid. If we know that, or we have reason to believe that work's being performed, we have to pay for it, even if we do not expressly tell them to do it. So, for example, if you have your star employee who you tell her to get the report done, she is an hourly employee, meaning she's entitled to overtime, and she stays past her 8 hours in the day and works overtime, even though you didn't ask her to. If you know or have reason to believe that she stayed late, you have to pay it, even if you didn't expressly ask her to work overtime. So on-call time, let's talk about on-call time. The key question with on-call time is, can the employee use on-call time for his or her own benefit? If the employee can use it for their own benefit, then we don't necessarily have to pay for on-call time. On the other hand, if they cannot really effectively use the time for their own benefit, then we do. So what does it mean? How do we measure whether someone can use on-call time for his or her own benefit? And here are the factors for deciding that. It's whether there's a geographic limitation placed on an employee. So for example, can the employee kind of go anywhere, or can they go home, or do they have to stay sort of in the neighborhood to get called back to work? Is there a required time to respond? Is it not a big deal if it takes them 30 minutes as opposed to taking 15? Number 3, the ability to trade on-call responsibilities with another employee. Can they trade it, or is it just for them? So if they're at an important family function and they get the call, is it okay? Are they able to call someone else to substitute, or are they really stuck doing it themselves? And is it possible that they can use a pager, or a BlackBerry, and iPhone to ease the restrictions? And then what are the personal activities of the employees while they're on call? If they can sort of do anything and just have a reasonable response time and come from their house or a pretty large geographic region, then you don't necessarily have to pay for the on-call time. If, on the other hand, they really have to be very, very responsive, and they have to be in close geographic proximity, and they're the one who has to do it, then almost always that call time is going to need to be compensated. So where are employers most vulnerable? I just want to point out, and I don't know, I know BlackBerries are getting greatly looked over for iPhones, so I should probably change the graphic on the slide, but nonetheless. one of the places that we're worrying about a lot is for when employees have iPhones or BlackBerries and they're being required to be pretty responsive. I think you need to be very careful for an hourly employee whether that time is really time that they're having to tune in and do work, and whether it should be compensated. This has kind of been a hotbed area, and we haven't yet begun to see all the reported case law on it, but we're being fairly careful to let employers know that either have a policy that talks about, an occasional email is no big deal, but really requiring people to be staring or notified all night long and respond to emails, that's an issue and probably a pretty good setup for having to pay someone for their working time. Here are just some of the questions that we're seeing. Is an employee who checks BlackBerry at home working? Should he be compensated for the time he spends updating his professional bio on Facebook or LinkedIn? Probably depends on the position. Or should the employee be compensated for the written updates he provides concerning the company's service on his personal Twitter page? Again, I would ask whether we've asked the employee to do that as part of their responsibilities, or whether we expect it, whether we know it, whether we're rewarding them for it. Any of that starts to become activities that look a lot like work that should be compensated. And then just here are some of the how do we discourage overtime work for non-exempt employees. The most important thing is the third one, which is having policies that encourage prompt notification from employees of hours worked. So what you want is to say, here's our overtime policy. We pay for time and a half, but you need to have permission and you have to regularly report your time. And then if someone works overtime that you did not authorize, you still need to pay it. If they weren't supposed to do it, then what happens is the employer is in a position to then discipline it, or the employee, give them a warning, and then if they keep doing it without authorization, then of course you can take action and discharge. But you cannot refuse to pay, even if you didn't ask for it, you cannot refuse to pay overtime if someone works it. Talk a moment about travel time. There's very specific rules about whether you have to pay for an employee's travel time. For employees that have a fixed work site, meaning they're coming to the office every day or a facility, it's all same-day travel other than commute time is compensable. And then for overnight travel, the passengers have to be paid, a passenger has to be paid for travel time spent during regular work hours that they normally work, or the weekend time if they normally work during the weekend. And they have to be paid, of course, for time spent actually working during the travel. So for example, if they're sitting there working on documents or doing calls or responding while they're traveling, then that's all working time. As a driver who's doing overnight travel, they have to be paid for any time that they're in transit. So now let's switch gears and talk about independent contractors. When is a worker not an employee? And I hope that for anyone who is paying anyone on a contractor basis, either I hope that it's a totally separate business and you're getting invoiced and it's very clear that they're not at all an employee, or you have a written independent contractor agreement that spells out and clearly shows the Department of Labor or the IRS or whomever that the worker is truly an independent contractor and not an employee of the company. And the number one thing that you want to ask yourself if you're in the situation of deciding whether someone should be an employee or independent contractor is whether that worker has primary control and independence. So with normal employees, they come to work, we give them projects, they're on our systems, they're sitting in our facilities, we're often giving them supplies or computers or whatever, and then we're very much managing them. For an independent contractor, there should be a lot more discretion that resides with the worker than in an employee situation. And this is another one I want to specifically call out, is there are a lot of different state law tests for independent contractors that you need to be aware of depending on what jurisdiction you're in. So here are some of the factors that show direction and control of a worker. If you came to me and you said, we have this person, gosh, we're paying them like an independent contractor, but I'm worried that they may actually be classified by the IRS or the Department of Labor as an employee, which would be a disaster because we don't know how many hours this person's working. They could claim overtime. We just don't know. So I would look at you and I would say, okay, here are some of the factors that I want to go through. Does this person provide their own tools, or are we giving them all their supplies to do their job? Do they have a separate workplace? Are they coming in and sitting in our workplace every day? That's a pretty big red flag that they're actually an employee. Do they hire their own employees? If so, that's actually very helpful because, as you know, you wouldn't normally have an employee who has their own sub-employees, but a contractor may have subcontractors or its own employees that it's using to provide a job for you. Independent contractors are typically hired for a project and they're not paid by the hour, although there are some exceptions there for consultants, but typically they're paid for completing a project and not on an hourly basis. An independent contractor does not have set hours. They set their own hours. They're just doing the project. They're not worrying about being there from 9 to 5 usually. Independent contractors are typically not terminable at will. They usually have a written agreement that sets forth the times upon which either party can end the relationship. The independent contractor has risk on whether they're going to make or lose money on any project that they're doing for you. They own their own clothes and they provide their own uniform. And the reports that they give are on a medium or a long-term basis, or they're project-oriented. They're not done daily or weekly like we would typically get from an employee. And one of the very important things is it would be a very unusual situation where you're able to provide any kind of benefits to an independent contractor. So if you have independent contractors who are getting vacation days or they're part of your benefits plans, that's a very big red flag, and almost certainly they should not be classified as independent contractors. So just to review the consequences of misclassification, if you have someone who really should be an employee instead of an independent contractor, you might have to pay back pay and liquidated damages, which is 2 times the amount, criminal penalties, unfortunately, which are fines of up to $10,000, and then willful penalties for $1,000 for each violation. And in a really bad situation, although it would take a lot to get there, you could have prison time. You could have payroll taxes. You won't be doing withholdings on someone who you thought was an independent contractor, so that will be screwed up. You'll have IRS and DOL audits, medical expenses. So for example, if someone says, gosh, they told me I was an independent contractor, had I been an employee, I could have been on the company's health care plan, but I had this horrible thing happen and I wasn't covered, but I should have been an employee, then you can have liability for that, which is obviously could be very high cost. Benefit plan issues, attorney fees and costs, and a number of other evils that all of us would like to avoid for sure. So let's turn now to our last topic, which is interns. And this is a pretty interesting one because I think that in many ways a lot of people assume here's a great way for us to give someone a chance to be part of the organization, to help the organization because we don't have a budget for this position, or I hear a lot of times, honestly, in professional organizations such as doctor or physician groups, you know, this physician has a family member and would really like him or her to be around for the summer to get some training, build a resume, help with a college application by being an intern. And that all sounds great. The only problem is when things go wrong with interns and the intern at the end of it says, gosh, I was entitled to minimum wage and overtime because I was working more than 40 hours a week, or I wasn't paid at all, and where's my minimum wage, then we have an issue. So I think that this, again, is a set of rules that a lot of people aren't aware that exist, and it's very important to be mindful of the risks of internships if they aren't structured properly. So, and let me just point out that when I'm talking about the risks here, I'm really talking about unpaid interns. If you are paying your intern, as long as you're following overtime rules, because they almost certainly won't be exempt from minimum wage and overtime, you're fine. If you're paying them, you're fine. It's the unpaid internships that are the issues and that we need to be very careful about. So here are the rules to follow if you're going to have an intern and not pay them. So number one, the internship must be similar to training that would be given in an educational environment. That's a pretty high bar. This is not having someone show up and sort of make the coffee and do the copies and things like that. This is really something that is supposed to be structured by the employer to look like an educational experience. So there really is quite a burden on the organization to make sure that this person is going to learn something similar to what they would be doing in a formal instructional situation. The second one is that the internship must be for the benefit of the intern as opposed to the employer. So what gets people in trouble is when they, for example, had a downturn in the business and they decide to cut employees and then they bring in an unpaid intern to fulfill some of those duties. The Department of Labor and the IRS say, no way. That's a really big problem, and you're really just replacing what should have been a minimum wage or a non-exempt position with someone who's not receiving anything. Third is the intern doesn't displace regular employees. So again, if you have gotten rid of an employee and then replaced them with an intern, that's a very big red flag. Fourth, the employer derives no immediate advantage from the internship. It's not that you can't receive anything, but if someone walks in and all of a sudden they're saving you money on day one, scratch your head and say, I wonder if this person is really a properly classified intern. Fifth one, the intern is not necessarily entitled to a job at the conclusion of a program. So here, what I'm talking about is a situation where you bring on an intern and you say, if you work here for 3 months without pay, then at the end we'll convert you to this position. That doesn't fly. What the Department of Labor says is what you're really doing there is getting 3 months of free labor, and you ought to be paying minimum wage and overtime for it. And then lastly, both parties understand that the intern isn't entitled to wages. And the last point is where I want to just highlight that that's where the agreement with the intern and a structured intern policy or a program is really important. Communication and having the intern acknowledge that they're not paid. Here's how the program's going to go. Get a good supervisor or mentor in place for that intern, and then you can structure something that's to the advantage of both. But interns, in some ways, if it seems too good to be true because you're getting a position filled that you're not paying for, it probably is. So just concluding, what's the takeaway from this presentation? The takeaway really that you should all be thinking is it's important to conduct regular audits. And again, what I mean by that is looking at each employee classification and going through and saying, is this person still in the position, has the position evolved such that it ought to be changed? Did they come in at one level that switched to another and now unfortunately they're not at that skill set that they were that entitled us to be exempting them from overtime? An audit is a matter of going through and looking at every person's job, their title, their responsibilities, and making sure that they are properly classified, and then looking for situations such as independent contractors where someone, again, may have evolved from what started out as a discrete project to someone who's really more like a full-time employee who needs to be managed all the time and is really properly classified as an employee instead of an independent contractor. So to conduct your audit, if you're experienced in that, a great starting point is to just gather everyone up, get their job descriptions, update job descriptions, and then some of them are very easy as we went through. I mean, some of them you can pretty quickly say this person's an executive or this person clearly has a degree that puts them, you know, such as the registered nurse, and that's really what they're doing, and that's fine. I think what you'll find is they're probably a percentage of your workforce where it's a bit more questionable. And that's where you want to involve legal counsel and say, hey, we've got this person, here's what they do, here's what their job title is. We need to know if we are properly classifying them as an exempt employee. So that's all I have in the presentation. I do have a number of questions, and I will be following up, but I am going to do just a couple of them for anyone who wants to stay on the line. Someone asked, what's the difference between exempt and salaried? And really, if someone is exempt, then it's proper to pay them a salary, whereas it's not okay to take someone who is not exempt, who should really be receiving overtime and minimum wage, and give them a salary. So they're supposed to be two sides of the same coin, but the problem is when you have someone who is not exempt and is receiving a salary. If someone else asks if an employee is salaried, doesn't that automatically make them exempt? The answer is no. That's the problem. If an employee is someone who is fairly, let's just say they're low level. Let's go back to an easy one, which is an administrative assistant. And you say, great, we want to make you a salaried employee. So does that necessarily mean that they're exempt from minimum wage and overtime? Absolutely not. And that's the problem, because you will have your administrative assistant, you'll have them not reporting their hours because they're getting paid a salary. And then the danger is the Department of Labor, the IRS, or the worker says, I was improperly classified as an exempt employee. I've been paid a salary, but in fact, I've been working 45 hours a week this whole time, and I want my overtime back for 2 or 3 years. So that's the danger with that. I think I let everyone know that we will follow up. A few people joined us, so just so everyone's clear, we will email out all the slides from this presentation. And I'm clicking through. I know I have a couple of more questions, but I think that what I will do is follow up with people separately on that. So with that, I think that we will go ahead and conclude the webinar. I really appreciate everyone's time today. I would really love to help any of your organizations with any wage and hour or any employment law questions that you might have. So please consider reaching out to me or one of our other attorneys at Holland & Hart. We'd certainly love to help you. Thanks so much.